What happens if an employee violates the non-compete agreement?
Typically what happens when an employee violates a non-compete agreement, an employer will contact an attorney and the attorney will send that employee a cease and desist letter, which basically says they have a certain period of time to either quit their job with the new employer that they have started working with that is, let's say, in violation of their agreement, or they can stop soliciting specific customers. But that's usually the first step an employer will take when they find out that an employee is possibly violating a non-compete agreement. What an employee should also realize is that a lot of times these cease and desist letters are sent on to their new employers, which can create a situation for that employee. Because a lot of times these new employers see a valid agreement or see an agreement and they realize that they're going to have to defend on behalf of this employee, and most of the time it's not worth it. So a lot of times the employee will lose their job. And in Florida, since it is an employment at will state, which is a whole other issue, but generally speaking, an employer can lay off an employee at any time for any reason. So these are considerations that the employee should keep in mind when they sign an agreement and after they leave employment. But generally, after a cease and desist letter is sent, if nothing changes, a former employer can thereafter go up and file a breach of contract action against the employee, and also seek some sort of permanent injunction against the employee to enforce the terms of the agreement, whatever they are, perhaps not competing for the remainder of their agreement or not contacting specific customers. And it can also expose the employee to attorney's fees, having to pay them to the former employer if the courts find that the employment agreement to be valid and enforceable. And it also exposes the new employer to possibly having to pay attorney's fees